Welcome to The People's View, a program dedicated to discussing local, state, and national issues and their effect on the American people. The People's View provides a platform for state representatives and national figures to present their viewpoint. Whether it's social, economic, or financial topics, you'll hear it on The People's View.
Welcome back to The People's View. I'm Kevin Avard, your host, filling in for Carl Seidel and Pete Silver. And today's show is sponsored by the Nashua Republican City Committee at NashuaGOP.org. And today I'm going to be hosting Dave Robbins. You're going to be joining us, and you're a candidate for Ward 9.
Yep.
And you're also a sitting legislator.
I am.
And welcome to the show.
Well, thank you very much.
You're actually one of the stars of the arts of politics.
Well, I think star is too strong a word. We have fun. We try to have fun. Right. And I really appreciate being on with you. And this is sort of the premier show on public access. So I feel honored. Thank you very much.
Well, great. Welcome to the show. I see you got the paper here today, and we're going to talk about a couple of issues in the paper. But right now, we were just talking off camera about the subcommittee that you just finished up, and hot topic lately on either Speak Up or in the House is the GALs and the boards. And talk a little bit about what the subcommittee was doing.
Sure. I chaired a subcommittee that is making recommendations to the full Child and Family Law Committee on two bills that we studied. One of them, and I can't specifically remember the numbers, I get them mixed up. So one of them had to do with allowing the Guardian Ad Litem Board to collect information from litigants and potentially from other parties, for example, judges, clerks, that sort of thing, GALs themselves, to try to provide information and feedback to get some kind of picture about how well guardians were doing, how well the process was doing, what questions came up. And one of the things we found, we went to some of the literature as we were doing this. The state of Wisconsin does this to a certain extent, and they have a whole survey system set up. What they found was that nobody responded. They would send out hundreds of these surveys, and no one would respond. So we are going to suggest that we move forward with this and still do it, but probably do it some kind of electronic format.
Well, what are typical questions that would be on the survey?
Typical questions that were on the Wisconsin survey were things like, to one of the parties, let's say, one of the litigants, did your GAL show up on time when he or she said they were going to? Did they spend time with you? Did you feel as though you had an opportunity to explain and express yourself? Do you feel that the GAL listened and provided a non-biased recommendation or factual summary to the judge? And those kinds of things. Specifically said that this is not a survey that's based on whether or not you, quote unquote, won your case. We're just trying to figure out how the process works. Now, the judges responded. And the clerks responded.
That's interesting.
But the people who didn't respond were the litigants. And it was something like 1 or 2% of this. They do it by counties, of this one county we looked at. And we think that if the committee chooses to go ahead and the legislature chooses to go ahead with this, we feel that we can still get something out of this. We can do it electronically. There are ways to follow up with people electronically, low cost.
Were they allowed to remain anonymous?
Yes. In fact, the survey results were not published per se in Wisconsin. They were available to the judges and people in the process, so that a judge might be able to say, for example, GAL Smith. I've got 5 responses back. GAL Smith never shows up on time. Never. All of the litigants say that he or she is not there when he says it's going to be there.
Right.
That sort of thing, so that the judges have the feedback. I think, and I haven't thought this through, and certainly this would depend upon the committee and the legislature, but I think there are ways that we could structure something simple that could be answered electronically, that even if we tried it out and it was sunsetted after a couple of years, to provide some kind of baseline data. Because the guardian ad litem board, and I firmly believe that these people are good, honest, sincere, hardworking people. They don't have any support. There's no way that they can do all of the things that they're supposed to be doing.
You're talking about the board themselves.
The board itself.
Not the guardian ad litem.
Right, no, the board itself.
Right, okay.
And we're asking them, it's sort of like going to a teacher and saying, you've got a child from 9 in the morning till 3 in the afternoon. If they're not perfect 24 hours a day, then it's your fault. I mean, in some ways, we're asking the guardian ad litem board, the way we've set it up, to do that same kind of thing.
I know that I personally get letters from people. Some people, they will be coming on the show, Speak Up, but they're afraid. They're literally in fear of their government and the guardian ad litems and the power, the unchecked power that they apparently have in certain areas. And we've heard many abuses. I don't know if they've come before your committee or your subcommittee, but you're actually basically dealing with the board at this particular, this particular. These are the actual guardian ad litems,
right?
Which may, in some, in some instances, they might be either biased one towards the other, not showing up at a school doing an interview and saying they did, asking for extensions or billing for extensions in advance, where each case is guaranteed $1,000. It's supposed to be $1,000, but they're overbilling. Then they're going to the judge saying, look, make this right. So there are many abuses that we've found on the redress committee that need to be examined even closer. And there needs to be a certain degree of accountability to the people, to the judges, which we're in the process. But now you had also mentioned something about Paula Imbertson being the chair of a particular.
There is a committee that's been set up. The Speaker has set up an ad hoc committee of state representatives, and Paul Ingbertson is the chair. Also, chair of redress of grievances. Is that correct?
Seem to go hand in hand. Well, he has a pretty good handle on the situation.
And Paul's. I personally, not only do I like Paul, but I think he's a very steady hand on the tiller. And when I've seen him, in action, so I think he's probably a pretty good person to have at this.
One of the things I think that Paul has that I think works to his advantage, and it can be very annoying, is that to a fault he's a perfectionist. He's an artist. I think you
Well, I know he is. I don't know anything about his work, but I know he's an artist.
He's an artist, and he definitely looks at the detail. And I'm all for that, and I think that's wonderful. And I think when I say to a fault, it's to the point where you have to have everything documented.
Right.
He doesn't want to go out there and say such and such, and then it be backed up. It just he doesn't, and nobody does.
Right.
And I think that's one of the advantages that he has. That when you come out of a committee, you know that, if you made this claim, you have to have that supported with a document. And that was pretty much the philosophy of redress. And frankly, it took us forever to get through some of these cases.
Well, I've been reading the summaries that you published, and actually in preparation for the subcommittee that I was working on, I went back and I pulled all of them and reread them because I wanted to see how many petitions had to do with the guardian ad litem and guardian ad litem board. And I think there were 27 or 28 petitions this year. And I think something like a third, no more than a third of them, had to do specifically with guardian ad litems or the guardian ad litem board. And I was surprised by that because given the smoke that has come up around this, I expect there to be much more fire beyond this. But so I'm not sure what's going on with that. I mean, 8 or 9 cases since the beginning of not just the 2-year period, but these go back years.
Well, one of the things, not everybody made it through if every, with this being the first year that the committee is around, I suspect that there's going to be a floodgate if next term, if the redress committee survives.
Right.
I know that some people don't want it to survive. They don't see the need for it, but I happen to be a strong advocate for the redress. But there are at least a handful of people that didn't make it through what is that, Rules Committee because of time. And regarding the board they came before our committee at one point, and basically we found them to have very, very little authority.
That's correct.
And so the smoke there wasn't or the fire there wasn't so much the problem, because they really can't do anything about anything anyway.
That's true.
And then later in the session, the Supreme Court gave the opinion that the guardian ad litem have quasi-immunity, making them very unaccountable to the people. So the fire is there. I think it's there. It's and I think a lot of people were hurt in a lot of different cases. Then it was documented, and I see a pattern. But I'm interested to see what's going to come out of this ad hoc committee that you'd mentioned.
Oh yes, I am also, and it's got child and family law people on it. It's got some folks from the redress of grievances, folks from other committees. I don't know whether judiciary is on there or HHS, but I know there are other people from other committees. So a lot of people with a lot of with varied backgrounds taking a look at this.
Right.
This leads into something else. There was a second bill that we looked at in this subcommittee, and it had to do with disciplinary procedures. And right now, if somebody's dissatisfied with a guardian ad litem, the GAL rules provide that if I'm dissatisfied and you're the guardian ad litem board, I can file a complaint about guardian ad litem X with you. And the board then has the authority to dismiss the claim if it finds it's without merit, to hold some kind of an administrative hearing procedure, to forward the claim to the judiciary. And what they do in many cases, most of the cases don't make it beyond the GAL board. They're either not followed up on or there's clearly nothing there. But the ones that do, the GAL board says we're going to defer action on this until after the case is heard. The bill that was put in and that we had hearings on specifically said the GAL board shall not have that option. They have to send these complaints forward. And we talked to folks in the judiciary. We talked to the GAL board. We talked to, we did talk informally with a GAL, and we talked, we had some people who, at least one person who was a litigant, come forward in the subcommittee hearing. It was about 2 or 2.5 hours long. And we ultimately decided to recommend that this was not a good thing to move forward in legislation. And the reason for that is, everybody said, the judiciary included, we don't have the resources. We don't, it smacks of forum shopping. If I'm a litigant and I'm not happy, you know, the GAL seems to be heading in a direction that I'm not happy with, then if I go to the GAL board and say, well, GAL Smith is biased, you know, or this, that, and the other thing, because whatever. If the GAL board then has to send that forward, what does the judiciary do with it? They don't have investigators. Nobody's got investigators. And these kinds of things really need investigation. So that we would either have to fund this, because there's really no way to get into this other than somebody sitting down and trying to look at a record and make a determination. And you and I have both seen some of these divorce and custody records. They're like this, And even if you look at the record, you don't know what's going on behind the record. So what do? Start interviewing people outside of court?
I think one of the things that a solution, I don't think the solution is with the board. I do think that we have to take away the quasi-immunity via statute and allow people to, if they can prove beyond a shadow of a doubt that the GAL lied or they acted outside of their purview or they showed a complete bias, that they should be able to be sued. And the reason for that is we have some parents that are separated from their children in the Vandenberg case for up to 3 years because of the GAL. And that GAL made about $40,000 off this one case, which is supposed to be $1,000. But because they've gone over and over and over and asked for extensions, that GAL has a lot of power, more power than the parent. And they're not following statute, they're not following rules. We got to document it. And there's no way to hold them accountable. I think that the people should have that right because they are actually a contracted individual. And they're not lawyers. Some are lawyers, some are not.
Yep.
It seems to be a good way for some people to make a lot of money, though, if they can keep extending the case over. And some of the things that they're bringing before the judge, the parents have no way of knowing because they're put in sealed envelopes. I don't think that's right. Because your child doesn't belong to the state. That's your child.
Yep.
And they have way too much authority. And I think they have to be accountable to both the parents and to the child because they're hurting the child as well if both parents are fit and good parents. But if there's one parent that has a grudge against the GAL, that GAL can just make life really healthy. And that's too much authority, way too much. So I think by statute, they should be at least held accountable if they do not follow the rules, protocols, and statutes, and lie. They need to be held accountable. Too much is at stake. There's too much abuse that is going on. And as you could see in some of our reports, I think it was in the Johnson case where, the courts allowed basically judicial child abuse. That's what we came to the conclusion. The child was taken away from the father. Father did nothing illegal.
Right.
Never been accused of any type of abuse. Not adjudicated as an unfit parent, and yet separated from their child. And now this not only happens to fathers, this happens to women as well, to grandparents. So I think and the solution isn't with the board. I'm not really sure what the board is what use they have. But as far as making the government accountable to the people, you should allow the people to have recourse against them.
Well, I certainly can't disagree with that, and I think that we all are accountable. B, we all have to be accountable. I mean, you and I are accountable to the 10,000 people in our respective wards, and every 2 years they get an opportunity to say thumbs up, thumbs down. If they don't like what we're doing, we're out on our backsides. If they think we're doing a decent job, they may give us another contract for 2 years. So I absolutely agree with you on the accountability. My sense is that the accountability connection should be between the GAL and the judge or marital master for this reason. The judge is the person who appoints the GAL. The judge ultimately is responsible for the decision. The GAL just provides a recommendation, or maybe just documents. Sometimes there's not even a recommendation. It's just a recitation of facts.
But Dave, what if the judge and the GAL have a conflict of interest and the judge doesn't recuse themselves, or the marital master?
That would be a judicial issue. That's not that's not necessarily a GAL issue unless.
But how does the citizen fight that?
That I don't know. How would if you are before a judge and
they have a golf
and the judge is your the other litigant's father-in-law, and the judge says, no, I'm not going to recuse myself. What do? You appeal. And there is an appeals process, a judicial appeals process, and there are times when this is what we learned at our subcommittee. The judge may say, no, I'm not going to allow this appeal to go forward, and at the same time, there is a way to get around that. However, that has nothing to do with the GALs per se. That's a whole judicial issue about judges and whether or not they should recuse themselves, who should decide. And for example, in the federal level, at the Supreme Court, the people who decide whether or not to recuse themselves are the 9 people on the Supreme Court. There's no appeal from that. So I really think that if there is a connection, and there should be an accountability connection, that's the way it should go. Second thing is, I think even if we did nothing, we're going to see over the next couple of years this kind of complaint going way down on new cases, and I'll tell you why. The state of New Hampshire used to fund a program where if people could not pay for guardian ad litems, the state of New Hampshire would fund this so that the guardian ad litems could be hired and paid by the state. That money's gone. Guardian ad litems I've spoken with are, they're not getting nearly the cases.
But Vandenberg spent $40,000 on the Guardian. That was not state money.
Right.
Youssef was $9,000 or $18,000. Haas was $9,000. Mr. Dow, excuse me, a factory worker, that was $9,000. And they were billing in advance. Excuse me, before they were even given permission. They were billing in advance. They weren't interested in the child.
Well, let me toss something out on that. I sat down. I sat across the table from a GAL, and I talked with him for a couple hours one day up in Concord. And at the end of our discussion, he's also a lawyer. And at the end of our discussion, he said, "You know, in talking, one of the things I learned early on in this process, the person who's been a GAL for 20 years, and do you know what, when a client sits down, private pay client, do you know what the first question is, or do you know what has to happen before the case moves forward at all?" And I thought, oh, you know, the judge has to send you a letter, this, that, and the other thing, and of course that's true. The client pays a retainer. And when you think about it, is there a lawyer in private practice who doesn't get a retainer up front unless it's some kind of you know, accident litigation or contingency litigation?
But doesn't statute say that each case is $1,000?
I think it is. I don't know how that plays into. I know there are ways to bill to go certainly beyond $1,000, and I honestly don't know where the cutoff is on this, and I don't know who has the authority. Is it the judge? Can the judge has the power to say you're going to pay $300 a week in child support, and you have very little recourse. Does that not mean the judge says, well, you know, I think a GAL is beneficial to this case, and so yes, you have to have a GAL and you have to split the cost, or because you have the money.
Yeah, I think what we've discovered, though, there are some major abuses with the individual. I'm not saying all GALs are bad, but there are many cases which have come before us and that are pending, and some that are actually in fear because of the abuse of power that they have. It's just clear cut as far as I'm concerned, and I do see the fire. I see a flaming fire, and I do see where some people have been egregiously injured, as well as the parents and the children. So you know, as far as legislation is concerned, I hopefully will be introducing some accountability more to them, because there is a situation and it's rampant. It's not just here in New Hampshire, it's actually around the country. And I just think that the children are being abused as a result of that, and that there's, you know, follow the money. It's the follow the money syndrome. So let's talk a little bit about local stuff going on. You mentioned something about the alderman.
Well, first off here, let me see if we can get a shot. There we go, a shot of this. The Telegraph, our hometown paper, love it. These guys and gals do a wonderful job, and I want you to keep that thought in a few minutes when I lambaste them for something else. I read it every day. If I don't get it, I like to get it in my hand because I'm one of those kind of guys, you know, ink, and but I also get it online. Editorial today. One of the aldermen suggested that there's so much incivility in the aldermanic council that I think we ought to pass a resolution that says if somebody's not civil, if somebody's not following the rules, we should fine them $10. And this is like anything else. There's a kernel here. There's something that's going on, and,
Right.
and Donnelly Lozo is quoted as talking about how in the past she has basically said to the alderman, come on, you know, guys, we're all working together. We gotta solve these problems. I mean, just sitting there and sniping at each other and being snarky is not a good thing. And they also mentioned the aldermanic, the president, the chair, got a little snarky, I love that word, with a couple of colleagues. So what does the Telegraph say about this? The Telegraph says, essentially, guys, gals, come on. This is not, you know, you're supposed to be nice. The people expect you to be nice. You got the business of the council, the city, the citizens to carry on. You know, do your job. I mean, this is not the way to go. This would just exacerbate the situation. And what really caught my attention on this was House of Representatives. You know, we've been accused of being dysfunctional. We've been accused of being mean and nasty to each other. We've been accused of all sorts of things, both from outside the House, inside the House, across party lines, what have you. And like anything else, there's something to this. That there is, I mean, something is going on. The question is, how do we address that? How do we play? I like that.
Candy.
I like that. Let's see. Wait a minute. We've got 400 people there who are kind of on edge anyway, so we're going to shove sugar in them.
That's what I
and they're going to be just they're just going to calm right down.
Yeah.
You know.
Well, there's sugarless candy.
Well, that's true. Yeah. That's true.
Well, that's one of the things that I really, when I was there, I thought, you know, it was a nice idea to reach across, because both candy went to both sides.
That was great. I mean, I sit right behind you, and boy, the candy goes every which way, and I try my best not to get in there, not because I don't want to play nice, but because I've got weight issues. And but it goes around, and it goes, and you sit right next to a Democrat. Is that correct?
Yeah, and a little mint doesn't help.
You know, it's breaking bread or breaking sugar.
Well, I give the chocolate to the ladies and the mints to the men, and vice versa. But
is it something about the men that they need the mints to their breath, or
no.
what?
You know, the whole idea was, you know, there was such a high tension, and for me to go over to the other aisle and hand candy over, you could see that the expression was, really? Yeah, please. We're here to serve the people.
Right.
And some would be takers, some wouldn't, obviously. And of course, there were more Republicans, so that went around. But it was just a way to break.
Did you find that anybody wanted to have somebody else taste it first, or is that
nothing like that?
No, okay, that's good. That's good.
Yeah, actually, they saw me giving it out to the other side. They were still living, so they just reached into the bag. But I think really, truly reaching over the aisle and looking at, I mean, some of the Democrats would come over and pat me on the back.
Yeah.
And you know, it can be civil. It doesn't mean you have to back down on your principles and stuff, but you can be civil. And it was refreshing. There were a few there that were very civil, but there's some, I don't know, if they had daggers. And then we're accused, I don't know. Bottom line is, I was being a little tongue-in-cheek there, but being able to reach across the aisle and shake somebody's hand, looking up in the eye and saying, you know, I can disagree with you, but you don't have to hate me. My gosh. And that happened on both sides. So. I was just thinking the alderman may be groomed for the House. I don't know.
Well, boy, maybe getting ready to take our places. I don't know.
So talk about the censorship thing.
Oh yeah, this is again. This is my favorite paper, our hometown paper. I love the Telegraph. I wish it were bigger. I wish it were bigger. Here's the story. Did you know that the Telegraph has a policy beginning right after filing season? The Telegraph will not, except in extraordinary situations, will not publish letters that you write, will not publish op-ed pieces that you write, no matter how good they are.
Letters to the editor?
Letters to the editor.
Private citizens?
No, you. And you know why? And it's not just you as an individual. Any person who's running for office, for state or county office. So that from the beginning of June until the beginning of November, if you and I write a letter to the Telegraph, and again with certain very small, there are a few exceptions, but if you and I write a letter or about something, no matter how good it is, if you and I write an op-ed piece, no matter how good it is, Nick Pappas won't publish it.
Now, why is that?
Their policy is, and I hope I'm getting this right, that there are so many candidates who could write in, and they seem to feel that candidates will write in talking about themselves and about how I'm Representative Smith and I'm wonderful because I sponsored Ice Cream Day, that sort of thing, that it would drown out the voices of other people.
Now, the National Patch doesn't do that. They actually publish when people have you have something to say. They're at Facebook. I don't know if you're on Facebook.
No, I get in trouble when I get on Facebook, so No, okay. I have to, when I write something, I have to think about it before I hit the send button.
Right.
Because sometimes, the fingers get ahead of the brain, and I find that on Facebook, we know about Facebook, and we know how sometimes something goes from here to here before you really think about it. Been examples that shall remain nameless. But I don't know of any other paper or any other media outlet, certainly written media outlet, that does this.
It's a form of censorship.
Well,
interesting.
This is a little bit tongue-in-cheek, but only a little bit. It really is a form of censorship. It does a disservice to the people of Nashua. It is I would almost call this a cowardly way out of a problem. And here's the problem. This would mean that the editors and the publisher of the Telegraph would have to make editorial decisions about what to publish and what not to publish. If you and I and our colleagues send in 100 letters, they might have to decide, wait a minute, we're only going to publish 5 of these because we want to have room for all of the citizens.
Right.
Or we're only going to publish 2 of these op-ed pieces this month from the ones that we think are the best. So what this would mean is the Telegraph would actually have to make editorial decisions on their editorial pages, on their opinion pages, about what opinions to publish. Now, I thought that newspaper editorial boards did that every day. I mean, I thought that, whether it's the Concord Monitor, the Union Leader, paper in Laconia, Portsmouth, wherever, any paper, they all make those kinds of decisions.
Are they not publishing what the private citizens are doing?
No, as far as I know, and I'm just relying on the statement by the Telegraph, and this was published a couple of months ago, about what they were going to do and why they did it. If your spouse wrote in, she is not running for office.
I see.
At least as far as I know.
No.
Okay. Her letter would certainly be considered for publication. If you wrote in, you probably wouldn't have a chance in hell of getting it published, at least until after the November election, because of this policy. And in fact, what I'm going to do is I'm going to write an op-ed piece about this. I've got it partially crafted, and I'm going to submit it to the Telegraph, and I'm going to ask them to either publish it or comment on it, and go from there. Because I really think that, for example, you are as close to an expert on redress of grievances as anybody I know. I mean, you've on the committee, you've done all this. If somebody, if there was an issue about the process that's followed by redress of grievance, or how, and I'm not talking about a partisan type of thing, but if somebody's raising an issue about, those people, they don't look at anything, they don't do this, that, and the other thing, you could write a letter or an op-ed piece, and you could say, here is what our rules and regulations say, here is what has happened, here is what we have tried to do to be even-handed about this, here is what other parties have done when we've asked them for information. here are some of the limitations that are imposed by whatever the systems are. I mean, you could provide the best information on that, but because of this policy, you're going to have to get it published in the Union Leader.
I'm sure they. You heard it here first. You're on people's.
Again, I love the Telegraph.
Yeah.
I feel good about this paper. It's, Nashua is such a wonderful size. You can kind of get your hands on it. You can get in. You can get involved in stuff. And the Telegraph does a good job on this. And some of the exposés and some of the feature articles, whatever one feels about Bill O'Brien, wonderful articles that in depth, trying to get into things. And they do a great job of trying to get into things and bring them up and bring them to us in a readable, informative, enjoyable way. You can't ask for more than that. But this policy, well, you can tell I've got, my hair's getting on fire over this, so I'll calm down a little bit.
Listen, we're going to be closing out the show real quick. You're running for office.
I am.
And you have a website?
I don't yet. I'm working with the wonderful folks at Vistaprint to get one set up. And I'm also trying to figure out how to get a PayPal button on the thing so that, because I've seen how people have done, had a $6.38 PayPal contribution on their financial report.
Yeah.
And I thought, wow, if I get 1,000 of those. But.
Yeah, I have a PayPal, so it's Kevin Avard.
Please, go ahead.
What's
your PayPal, Kevin?
Just send it to Kevin Avard for state rep. I really appreciate you being on The View. Is there anything else that you want to leave our viewers with?
Well, only that I'm running for re-election. I'm going door to door. Was going door to door this afternoon for about an hour and a half, and talking with people. One of the things that I do as I try to reach out across party lines is I tell people, if you care to contribute, that's wonderful. I have a limit of $50. I won't take more than $50 from any individual, any organization, party, or what have you. And I think that just provides so that there's absolutely no question about who I'm working for. And I'm working for you folks. I'm not working for anybody else. And if you think that what I'm doing is good, welcome any kind of contribution, support, but max it $50. So that's.
Well, best of luck to you.
Thank you, and the same to you, Kevin.
Thank you. I could use it. I'm actually being primaried, so I could definitely use some help. Today's show is brought to you by Nashua Republican City Committee and NashuaGOP.org, and we want to thank you very much for watching the People's View. And until next week.
Thank you.